problems from the insurgencies from Boko Haram getting more daring by the day.
On Saturday night, we got the news of the kidnap of the immediate past president of the Nigerian Bar Association, NBA. The leadership of the bar has described it as shocking. On our interview segment, we chat with senior advocates of Nigeria, Moyo Onigbanjo, on the Adamawa court judgment, which reinstated Mr. Balangilari back to office. We also talked about the perceived clampdown on the judiciary in Ekiti State and more. That's our lineup on this episode of Law Weekly. I am Shola Shieli. Welcome. The legal community and indeed many Nigerians were jolted when the news filtered out late Saturday night that the immediate past president of the Nigerian Bar Association, Mr. Okewali SAN, was kidnapped Saturday night in Port Harcourt, the Rivers State capital. The sad incident was said to have occurred at about 9 p.m. Mr. Okewali is largely based in Port Harcourt and was in fact a former Attorney General of Rivers State before he became the 26th president of the NBA. Confirmation of the sad incident came in very early this Sunday morning when the current president of the NBA, Mr. Augustine Alege SAN, issued a statement expressing shock and condemning the incident. Mr. Alege described Okewali as a man of peace who has contributed immensely to the enshrinement of the rule of law, the protection of human rights, and the development of the nation. The NBA therefore called on the federal government to step up efforts to fulfill its primary role of providing for the welfare and security of all Nigerians, even as it passionately appealed to the abductors for the immediate and safe release of its former president to his family. In the recent past, another senior advocate, Mr. Michael Zekome, a judge of the Delta State Judiciary, and some family members of Justice Bode Rhodes-Vival of the Court of Appeal have all been victims of the insecurity plaguing the country. While we remain hopeful and upbeat that Mr. Okewali will be released soon, let's do a quick recap of some of the top stories that we tracked in the course of the past week.
I write Honorable Ahmad Umar Finturi.
We begin reports that the former acting governor of Adamawa State, Umar Finturi, has filed his notice of appeal challenging the federal high court verdict which removed him from office. In his appeal, Mr. Finturi insisted that the ousted governor of the state, Murtala Nyako, received the resignation letter of his deputy, Balangilari, before he was impeached on the 15th of July. The impeached governor, he claimed, also nominated a state legislator, Adamu Kamale, to replace his deputy. In his 8-ground notice of appeal, Mr. Finturi urged the appellate courts to set aside the judgment which removed him from office on the basis that the trial court erred in law for not giving room to call witnesses to prove that former governor Murtala Nyako actually received Mr. Ngilari's letter of resignation before he was removed as governor by the State House of Assembly. Justice Adeni Ademola of a federal high court in Abuja last week Wednesday in his judgment had held that the purported resignation letter by Mr. Ngilari was of no effect since it was addressed to the Speaker of the Adamawa State House of Assembly instead of Mr. Nyako, who was then the governor of the state. Staying with political issues, the appeal court sitting in Akure, Ondo State last Friday threw out an appeal filed by the Independent National Electoral Commission, INEC, and the Osun State Resident Electoral Commissioner, Ambassador Toyin Akeju, against the judgment of the Federal High Court, Oshogbo. The Federal High Court had in February 2011 restrained Mr. Akeju from presiding over the affairs of INEC in Osun State, following a suit by the People's Democratic Party alleging that the REC was partisan in the handling of the electoral process in the state. But INEC and Akeju, not satisfied with the High Court judgment, approached the appeal court in Akure to set aside the judgment of the lower court. The case, which was finally decided by a 5-man panel presided over by Justice Michelia, rejected the appeal on the basis that the notice of appeal was not properly filed and that the entire process was therefore null and void. The appeal court also held that the judgment of the Federal High Court in Osogbo restraining Akeju remained extant and should be complied with. to the suit filed by the governors of the 36 states of the Federation against the federal government challenging the manner of the deduction of fuel subsidy funds from crude oil proceeds, the Supreme Court has slated December the 8th for hearing. The governors who sued through their respective attorneys general described as unwholesome and unconstitutional the practice of deducting the fuel subsidy fund and other expenditure from the oil proceeds before it is paid into the Federation account. They claim that their various states had been shortchanged through the deductions by the Nigerian National Petroleum Corporation, NNPC, on the instruction and authority of the federal government. They also argue that the practice, which they urged the apex courts to stop, had led to inaccuracies in the oil revenue remitted to the Federation account. Through their lawyers, the governors are urging the Supreme Court to, among other prayers, declare the practice a violation of the provisions of Sections 88 and 162 of the 1999 Constitution of Nigeria. A former president of the Nigerian Bar Association, Olisa Agbakoba San, has dragged the Nigerian army before a federal high court in Abuja to challenge the death sentence passed by the military general court-martial on 12 soldiers. A 9-man court-martial had on September the 16th, 2014, pronounced 12 Nigerian soldiers guilty of mutiny and consequently sentenced them to death by firing squad. But Mr. Agbakoba, in his suit, is contesting the legality of the military tribunal. The suit, filed under the Fundamental Rights Enforcement Procedure Rules 2009, is seeking, among other reliefs, a declaration that the convening and composition of the Army's General Court-Martial, which convicted and sentenced the 12 soldiers to death, is contrary to Section 36, subsection 1 of the Constitution of Nigeria, 1999. Agbakoba wants the court to set aside the death sentence on the 12 soldiers. And we round off in Kenya, where Uhuru Kenyatta has become the first sitting president to appear before the International Criminal Court in The Hague. The Kenyan leader attended a key hearing aimed at determining whether the charges of crimes against humanity leveled against him will be dropped or postponed indefinitely. Kenyatta, who appeared at the court last week Wednesday, was greeted by a crowd of cheering supporters outside the courtroom. Inside, however, he kept mute while his counsel, Stephen Kay, made his submissions, urging the court to acquit him of the charges. The charges, which Kenyatta denies, concerns his alleged role in the violence which followed the 2000 elections in the country. More than 1,000 people died in the aftermath of the polls. The prosecution accuses the Kenyan government of obstructing the investigation. The ICC, however, wants the Kenyan leader to explain allegations that evidence against him was being withheld by the Kenyan government. The hearing was later adjourned.